Good afternoon, ladies and gentlemen. Welcome back. The next talk is The Rule of Law, What It Means and How to Spread It. Would you please welcome Sir Geoffrey Jowell QC, Andrew Gilmore, David Marshall, and asking the questions, Oscar Guardiola Rivera.
When I'm not getting happily merry while dining here at Traquair House, thanks to the hospitality of our wonderful hosts, I teach a course on public law at Birkbeck School of Law back in the University of London. Consider the situation. A Colombian, myself, teaching a multinational audience, Asians, Africans, even some Latinos, even some English, about a constitution that may or may not exist. I call it my class on magic realism. The question, the magic question at the heart of that class is the one that gathers us here today. What is the rule of law? What does it mean? And the second, no less controversial question, how to spread it. Controversial because of what it assumes and the very idea that someone must or can spread something. I have a most distinguished panel with me to discuss that very issue. And to kickstart the proceedings, I'm going to engage in shameless self-publicity and read a very short excerpt from this wonderful book titled A Story of a Death Foretold, which you can find out there, by the way. This is the reaction of a non-lawyer confronted by the paradoxes of the rule of law. This non-lawyer is none other than the famous Argentinian writer Julio Cortázar. Cortázar had no illusions about the power of the tribunal. The tribunal in question is the Second Russell Tribunal, or the human rights discourse and rule of law it helped develop. In the absence of even a handful of United Nations blue helmets to stand between the bucket of shit and the prisoner, between, say, Victor Jara and his torturers, he said, it was difficult to avoid feeling that, though important, to develop a culture of human rights and the rule of law in response to the wrongs of the past might not be enough. In getting to grips with what happened in Chile, the members of the Second Russell Tribunal Tribunal were faced with a fork in the road. They could choose the path of developing a culture of human rights based on feelings of importance and guilt about always being too late, anxious about preempting the next Holocaust, and prosecuting others just to show that ours is not a culture of impunity. Or else, they could opt for the path that had started in the Nuremberg trials. Encourage underlings to document and question illegal orders and bad laws. Take such documented harmful measures as all the more reason for prosecuting higher authorities. Make justice more rather than less urgent. This would entail taking seriously the claims of remedial justice and greater equality put forward by those injured by the harmful measures that higher authorities take in so-called emergency situations. It would also entail providing the legal and political conditions that would make it possible to issue arrest warrants against higher authorities that give illegal orders or pass harmful measures everywhere, especially if they seek to excuse themselves under the pretext that they were obliged to produce such measures to contain emergency situations. This would require a prosecuting council ready to act against such authorities in the global north as well as in the south. The year was 1973. Do you gentlemen think that We're still facing the same fork in the road. Have things changed from 1973 to now? If so, how? Let us begin with you.
Thank you very much for putting me on the spot immediately. I thought I was number 3 in the list of speakers. I want to thank the festival.
It's just because of your lovely...
I think it's my Paul Smith kerchief. And I also want to thank Mark and the organizers for inviting me here. And let me say at the outset that I speak here in my own capacity, not in my capacity as a UN staff member. I think there's 2 major issues that we face now, and if I may speak here on behalf of the international community, I will. I think we face a crisis in conceptually what is the rule of law, and I think also operationally what has become the rule of law from a field perspective, looking particularly at the international community's endeavors at state building. In this country we have Dicey's definition, we have Lord Bingham's definition, but I was quite struck by an event that you may all remember, September 2012, when the world gathered together in New York and came around a consensus document, which is the Declaration on the Rule of Law. There was in New York, as Andrew may remember, a lot of noise around the preparation to the world coming up with the declaration. And it was during that discussion amongst member states that I was struck by some comments from member states saying that we need a model. What's the model rule of law that we should be projecting? And I was struck by that comment because I was thinking, is there a model rule of law? Should we be talking about models and then taking that model in our toolbox and taking it elsewhere? And what's striking about that, as you may not recall, but when the global community gathered around a consensus view of the rule of law, it removed supremacy of law. It removed public consultation in lawmaking, which for common law lawyers, supremacy of law, both to Dicey and to Lord Bingham, of course, are at the center of the rule of law. I'm still struck, I think, by the uncertainty as to what the rule of law is conceptually. Operationally, the rule of law has become basically a law and order narrative. Most of the rule of law work that you see, particularly in fragile states, the international community's work on helping states rebuild, is predominantly around reforming institutions of criminal justice, and that's predominantly around policing and prison work, building walls, providing batons to police and training them. All of that, of course, is important. Support to coercive institutions, of course, is a key element of the rule of law, I'd suggest. But if that's what it is, law and order, I would suggest to you that's a very impoverished view of the rule of law. But that's where we've become, I think, in 2014. Institutionally within the UN, we have a rule of law and security institutions architecture, both in New York and the field. The sections and units that deliver rule of law are often called rule of law and security institutions, and they tend to focus on policing, issues around mines, and security sector reform. And I think that I think both the UN and I think the international community has become unmoored from what I would suggest, and given I work for the Human Rights Office, it may be somewhat predictable, but sort of a human rights-based approach to the rule of law, moored in the individual, not in the institution, moored in the person and rights around his or her personhood, about equity and fairness and equality. So we've come a long way, but I think that we're sort of lost now. We've got lost in this edifice of rhetoric and process, and also lessons learned. I mean, I'm really hoping that after what we've seen recently in Iraq, that there'll be a deep, profound stock-taking as to who we are in the rule of law movement and what we're trying to achieve.
Jeffrey?
Well, I direct a centre named after Lord Bingham, Tom Bingham, who you've just mentioned, who wrote a book towards the end of his very distinguished life as one of our greatest judges on the rule of law. I'm sorry it's not on the tables outside, that's partly my fault. But he shows 2 things. First of all, that the rule of law is not a purely Western concept, it's for everybody. It's at the very root of the respect for equal human dignity. That's what it's all about. I agree with you, it's about people. But he also shows that the rule of law is not vague, it's not uncertain. He gives a definition, which I won't repeat now. He gives 5 ingredients of the rule of law, which I think can be summarized. And I think one of the problems is that there are 3 aspects of the rule of law that need to be unpacked. The first one you've just mentioned, law not anarchy. So the rule of law and not man or woman, the rule of law and order, and not disorder and anarchy. So that's the first aspect, rule of law, and perhaps we've got stuck there to too great an extent. I would tend to agree with that. The second part of the rule of law is rule of law and not despotism or tyranny, which means certain laws, not laws sort of out of the top of somebody's head, change all the time, retrospectively applied, and law that's equally applied to everybody, the poor and the rich, the marginalized and the powerful. It's a very powerful concept under the richer notion of the rule of law, of equality there. And then there's a third aspect of the rule of law, which is somewhat different, which is access to justice, so that everybody can challenge decisions that are made about them. The more we think in the Bingham Center about the rule of law, so what is the essence of a rule of law state? Can you challenge a decision from the highest authority to the lowest, to your local councillor, to the president, him or herself, and have a reasonable chance of success in the courts because you can get into the court or some other institution, you have a fair trial, and the judiciary are independent. And if you don't have all those three aspects of the rule of law, a very richer notion of the rule of law, which includes access to rights, then I think you have an impoverished concept of the rule of law. And I think one can only understand that by broadening that general definition. But there's nothing vague about that. There's nothing Western about that. It should apply to everybody.
Would you agree, Andrew?
Yes, thank you. Similar to David, I work at the UN and have done so for 25 years. And as I see it, rule of law, there are essentially two pretty unrelated aspects to it. One is rule of law and how member states of the UN, how states behave towards one another. And there, of course, you see grave disparities. So the point we just heard from Jeffrey about equality clearly doesn't apply when you have a big state having a confrontation with a small one. And then you find tremendous double standards and also hypocrisies. I mean, just to take, for example, reading this morning's press about the Russian convoy that's gone into Ukraine, whereas only 2 months ago Russia was arguing very, very passionately that the international community did not have the right to move a humanitarian convoy into Syria without the approval of the government. But clearly the Ukrainian government has not given the approval for this. So that's an example of A, a double standard, and B, a great disparity. So you see on the one hand the relations of member states, but in the other context, and David referred to this, it is the effort of the international community to promote law and order, or the rule of law rather, that's a vital difference, I meant to say, rule of law in particular countries. And those countries are those mainly that have just come out of a sort of burst of bloodletting or a civil war, where there is a desperate need to bring some semblance of justice, which is why in a country like the Central African Republic, which has descended into utter anarchy in the last sort of 10 months, the first two things one tries to restore, one is security and the other is justice. Because without justice, those who've had their family massacred, there's only one recourse, and that is to prolong the civil war and to take vengeance. So I think the international community has worked very hard on this, and particularly in David's field. I mean, there are 18 Security Council mandates at the moment for specific countries where there is a vigorous rule of law program. So these are two very different aspects of rule of law within the international, the UN context.
So Jeffrey, you just mentioned that very important third element concerning the rule of law, access to justice. But as I'm sure the public is aware, in this country at least, to begin at the domestic level, the cuts to budgets and legal aid might mean that, in fact, the very few, the rich, in fact, will be the only ones who could access justice. Can we then say, or shouldn't we say, that although in theory everyone agrees on what the rule of law stands for, when it comes to the practical politics and the application, the rhetoric stands for little or perhaps nothing?
Well, I would agree that cuts in legal aid, if they prevent access to law, by people who really cannot afford it, then we are diminishing the rule of law. The rule of law, like democracy or liberty or human rights, is very rarely, if ever, perfectly achieved. It is an aspiration, but it's a marvelous aspiration. And even in these terrible times, and over the past couple of days, we've heard harrowing stories, not only of, initially last night we heard poetry from the First World War, and that was ghastly and grueling enough. But today we hear what's happening constantly as we speak in different parts of the world, too many parts of the world. That doesn't mean one should throw up one's hands and say, well, what's the rule of law? I think perhaps we should even intensify our efforts, as frustrating as it may seem from time to time. But yes, we've attacked the reduction in legal aid, particularly for judicial review. We have questioned the government's intention, they've climbed down on a few points, to make it far more difficult for people to sue their government. In our view, judicial review is one of the central features, as I've mentioned, of the rule of law. And in terms of how one applies these things in different countries, far too often we find, both from programs of the UN, as good as they are, and from our own Department for International Development, for example, it's very difficult to convince those who have the power to allocate funds to projects that the rule of law should be much more than law and order. But it should be what happened in South Africa, building a culture of administrative justice, building a culture of independence of judiciary. And that's how it all begins. To achieve it perfectly, probably difficult in all countries, including this country.
That following up from that very same point, in the case of the United Nations, in your book you call for radical reform of the way in which the UN has been approaching its support for rule of law and state building. What is it that the UN has done wrong? How can it do it better? And in addition to that, and perhaps the latter goes to the three of you, isn't it the case that in spite of the fact that, as Sir Geoffrey suggested, the rule of law in principle is a universal concept, not a Western concept, it is more often than not used by powerful nations, veto holding nations, for instance, as precisely a stick to, with which to beat other nations and tell them that they're not doing well and that they will also be defunded. Let us start with the first.
So in response to your first question, I think that, the movement, which I describe in the book, really has become an industry, has exploded since 2003. Out of nowhere, we have over 1,200 NGOs that have expertise on the rule of law. We have thousands of guidance materials, lots of experts, all English, mainly. All the guidance materials are all in English. Very little in French or Spanish or any other official UN language. I think that the Security Council has got wrapped up in that, what I call the rhetorical runaway train about the elixir that is the rule of law. If you only have the rule of law, you will ensure economic development, you will ensure human rights for all. So a bit more modesty, the book calls in terms of the way forward is a bit more modesty in the goals. As you know, it's a bit of a cliche, but modest goals are clearly more achievable. The Security Council's mandates it gives to us, the UN, the Secretariat staff, and others, are overblown. They're comprehensive, holistic approaches to justice reform. These haven't worked. There's been very modest success in comprehensive approaches. And the comprehensive approaches are often moored in a law and order approach or a criminal justice approach, or moored in institutions. And certainly in the work where both Andrew and I were in South Sudan, where the local justice, the key deliverer of justice is the tribe. There are no institutions. The institutions have failed the people of South Sudan. And the 65 plus tribes, 64 of which have an oral tradition, judicial tradition, and address civil and criminal cases through that tradition, not through a so-called formal institution. So a bit more modesty, if we can possibly get off this train of comprehensive, holistic approaches. We have language we like, which is sort of rapid deployments and quick wins. This is not the language one should use with respect in rule of law reform. These are forever endeavors. And I like a great quote from Gordon Brown, as said to Michael Woolcock, who's a colleague at the World Bank, which is the most difficult thing about building the rule of law is the first 500 years. So can we please bear that in mind as we help states who do need help in building a culture of law, respect for law and respect for equity and fairness.
If I'm allowed to press on the second part of my question, Andrew just mentioned the case of the Russian convoy. One could also mention the incredible, to say the least, fact that the President of the United States comes out and says, yes, actually we torture some folk and nothing happens. How can one truly speak of anything resembling the rule of law when those things are happening?
I mean, of course, it's a, I don't want to sound cynical here, but it's clearly, anyone working in the international arena has to be aware that there are, as I mentioned earlier, tremendous double standards. It doesn't mean you don't deeply regret them and work your hardest to minimize them, but I agree, in absolute terms, you can't talk about rule of law, and you are quite right. The veto is used by at least 3 members of or 2 actually, the Russians and the Americans. The other 3 rarely use the veto. There's an implicit threat, but it's very, very rarely used by the Chinese, French, and British. And the other 2 are very happy to use it, and particularly in defending, in the one case, Israel, and the other case, Syria. And there's clearly, there's no equality before the law there if 2 member states can use that right. So I would say it is deeply flawed. There's no doubt about it. I think your question also was, what was your question? Prior to that, was about how do we make it, not how to make it better.
Well, if it is the case that the UN is not doing its job the way it should, and if it is the case that we have such disparities and inequalities when it comes to the application of the rule of law, how can we make it better? Should we even speak of spreading it as if we had something, a toolbox, as you put it, that can be applied here and there and everywhere and is just all the same?
Yes, because so that was what I was going to say. Clearly, there are grave shortcomings in the programming of the rule of law, and but it doesn't mean that from that conceptually they were wrong. Even though if they are seen as a Western agenda, in the debate just before lunch, we had Yasmin Al-Brown talking about the gay rights and assailing the Commonwealth for not being stronger on that position. But that is a Western position, frankly, and there are many other. I mean. So was the abolition of sati in India in the 19th century. It doesn't mean they're wrong, but coming up against local traditions, and David mentioned South Sudan, I mean, where there are cases, and it was really, really hard to know how to handle them. It's perfectly okay in South Sudan. If you can't find a criminal, you just arrest his son, and he may be 5 years old, but you throw him in jail. Or alternatively, the 5-year-old may be in jail because if he wasn't, then the other tribe would come and kill him. And that is considered perfectly okay. And then we come along and try and say, look, chaps, isn't a perfectly good idea. And it's seen as a Western agenda. But it doesn't mean it's wrong to try to change those practices. But it allows other people to say, you're barking up the wrong tree, that this isn't the way to come and impose your values on another people.
So, Geoffrey?
Well, I think that one of the things we can do is approach the issue of spreading the rule of law in a modest way. We have to, because whatever solutions are found have to be rooted in the local soil, in the local culture, in local traditions. So, for example, we're working at the moment in Burma, Myanmar. Aung San Suu Kyi is chair of the Rule of Law Committee of Parliament. She commands certain amount of support in Parliament. She's the leader of a small party at the moment. She was keen that she should be able to form a rule of law committee in Parliament, and she's the head of it. For her, one of the most urgent tasks is the actual implementation of human rights that surprisingly are in the 2008 Constitution, which was drawn up by the military. They are there, but they're not applied, they're not implemented. How do you do that? The judges are totally unqualified, and they're also very corrupt. So what do you do? Well, there are models. You could say, well, in South Africa, they created the judiciary at the time of Mandela's taking over was all white, all men. They couldn't perform the task of transformation that was required, so let's form a constitutional court that is a new court, that is diverse, that is more representative and different. And then other transformational reforms will follow. That worked. But there are other models. In Eastern Europe, there was lustration. Get rid of all the old judges and diplomats and professors without a fair trial. Nowadays in Kenya, they're vetting the judiciary for corruption, for incompetence, but in accordance with a fair trial, in accordance with the rule of law. So we can present that, and we are presenting that to Aung San Suu Kyi, and we're saying, look, perhaps you ought to bypass them. Let's create ombudsmen. There's so many models to choose from, and let's try and stay there some time, understand your institutions, listen to what you have to say, not just come out once or twice with senior judges telling you how to do it in the Western way, but listening and adapting and trying to find new institutions that will work to bring about the rule of law, because that is the important quest there at the moment.
Isn't the other problem the fact that when we think about the rule of law, most of us immediately assume that this is something that has to do with the state, that the law is state-centered, that it is the job of the state to apply the rule of law, and in the process we forget the fact that law is not just state law, but there is a variety of shades and colors of the law. If so, how can we make our notions and our practical tools concerning the rule of law much more nuanced, much more sophisticated? I love your word, modesty.
Well, just quickly, just how about, deepen our knowledge about context. It's, again, it's a bit of a cliche, but about context, history, language of the places that we've been asked to work. Rather than an importation of a model in our toolbox that if you build your model that looks like our model, you're good to go. This has proved not to work. Please see Afghanistan, Iraq, and other places. So if we can deepen our knowledge, I'm struck by the World Bank, which has decided recently to move into the rule of law field, to send its staff to the region for 4 years, to learn the local languages, to learn local traditions, understand, lowercase c, the culture of law in that country.
It was about time.
About time, true. So yes, just a bit more modesty, and a bit more humility, if possible.
Yeah, I completely agree with what you say. We're working in, sorry to bring this up again, but in Burma, on two levels. One, we're working with the members of parliament to talk about constitutional reform, different models of federalism and so on, and of the judiciary. And we're also, with the help of various other bodies, we've been rolling around buses, translating our materials on constitutional options into Burmese, and having 3 or 4 buses going around to small villages, towns, and marketplaces, and asking the people what they thought about these, how these problems ought to be solved, what they thought would somehow adhere, would have traction in that country, and then coming back to Parliament with those solutions. And that's the kind of thing, I think, that can be done, thinking of what empowerment of the people through the rule of law, giving them the opportunity to challenge decisions that are made about their lives, is as important as working with the state. But the problem is that you've very often got to get the state, whose interests may not be to hand over power in that way, and to devolve it to that extent, to agree to that.
And if I may just add, and even if you cross T's and dot your I's and you get everything right and you understand local context and cultures and language, this of course is my own opinion. Justice systems are often engines of injustice. Please see the state courts in Texas. Please see the courts in Basildon. I've worked in both. So even if we get everything right, justice systems are engines of injustice. And I mean that not only in terms of wrongful convictions, but in terms of how punishing justice systems are on witnesses, on victims, on the legal establishment. These are, even in democratic states, they're quite punishing processes.
I was just going to touch on that point. What happens when the rule of law itself becomes illegal or is potentially illegal? You just mentioned 2 examples, but of course we have also been reading about what happens in Ferguson in Missouri. There, the black community sees the law and all the institutions which are more present to them as themselves the source of injustice, lack of law, and disorder. How can we, to go back to the second question, how to spread it, how can we change that situation? How can we make it possible for those who have always seen the rule of law as the source of injustice to see it as also a tool which in their hands might make justice?
Well, the rule of law has to be applied by lawyers, and applies to lawyers and to judges. And in the Soviet Union in the old days, they used to have what were called telephone judges, who also would, if there was ever a case against the party or the state, they would telephone headquarters and say, how should I decide? And they were known as, they were all telephone judges. And in other countries, judges accept bribes from the powerful, so justice is sold. Simply because they happen to be the judges doesn't mean that they represent the rule of law. They're representing a distorted view of justice, and the rule of law must be brought there as well. And it's a hard thing to do. But certainly in a number of Eastern European countries who also had these telephone judges, there have been major reforms, and we should take heart from that. We should see what the Venice Commission has been doing, working with those countries, actually helping changing their institutions in the way that I've described, and the many different models that can be applied. And so the Venice Commission, which is the Council of Europe, not the European Union, the Council of Europe's body, the other arm of the Court of Human Rights, the European Court of Human Rights, always goes to countries with rapporteurs from different places, from East Europe, from Central Europe, from Western Europe. And that's a good model because at least there's more to choose from locally.
Absolutely wonderful. Let us now hear from our audience. If you have a question, please, Sir Kieran.
It's on?
Yes.
Sorry. I recall that the late Lord Justice Denning said many years ago that the rule of law is much older than democracy and much more important. Is that a view that the panel would share? And by the way, I think he's talking about the Bingham concept of access, because he also said something about "Be ye never so mighty, the law is above ye."
Well, it's very difficult to place these things on a scale from 1 to 10, but democracy is deeply important because it imports a notion of equality right from the start. We all have an equal vote, that is, if there is universal suffrage. And from there you build up a notion of equality, equal application of the law, the rule of law. They are intertwined in this country. You mentioned this, how did you describe it? The magical realism, a marvelous phrase about our Constitution. I often think that some people think that our Constitution is not worth the paper it is not written on. But even though it is not written down, we do have a democracy, and there are electoral laws, and we do have the rule of law, not perfected, never perfected, often slips, but basically it's there, and it's a principle. It's a principle. So we live by those principles in this country, whereas in other countries they have constitutions. Are they of equal value? I think they're completely intertwined, as with human rights and liberty and other great concepts which we should always seek to strive, but will never quite perfect.
How Aristotelian of the middle way. You had another question. The microphone is just coming.
Excuse my ignorance, but in this rule of law, who's laid down this law? Whose law is it? What law are we talking about?
It's
Extremely good question.
you want to
Let's,
I'm
yeah.
sorry, Charles.
I'm happy to kick off because and you're welcome. There's the book. There's a chapter on the book which is outside for sale at a great discount if you're interested, which answers your question. Because colleagues at the World Bank have suggested, and I agree with them, that can we stop talking about the rule of law and talk about basically the problem. I'm particularly talking about what we're doing in the UN and the World Bank at helping fragile states develop a road to peace that's sustainable and lasting. Let's talk about identifying the injustice, the insecurity in that place. Let's not talking about bringing the rule of law and having, what's the injustice? And it's often nothing to do with criminal justice. It's often, my experience in Yemen was land and water right deficits and challenges over property rights. So, in my humble suggestion, no more talk of the rule of law and talk about the injustice, the insecurity, and helping alleviate those issues.
Jeffrey?
I like talking about the rule of law because I direct a rule of law center. I don't consider myself industrial in the slightest. I'm not part of an industry. I think we do modest work all over the world. We're working now, I'll come to your question, with the Palestine Authority on the West Bank, who have come to us and have come to this country, even though, as is often said, they're not terribly keen on us, the Balfour Declaration and so on. They revere the rule of law in this country, and we're seeking to balance the tasks of the Chief Justice and the Judicial Council with those of the Ministry of Justice, and they're coming to spend time in the United Kingdom to look at how we do it as a single model, and then they'll look elsewhere as well. They call it the rule of law. Where does it come from? I think it was Aristotle initially, possibly as far as I can remember, who said the rule of law and not man, when I would say man or woman. And the opposite, and you know it when you see it, or you know it when you don't see it, as is said by Jim Goldstone in this excellent book, which you haven't mentioned, edited by David Marshall. Why am I doing your work for you?
He's good at that.
The International Rule of Law movement, and he said, if somebody is interned without trial, that's not, what is it? It's not the rule of law. If you go before a judge and the judge doesn't listen to you, he's written the judgment before he comes into court, or he doesn't hear you out, or won't give you a lawyer, that's not the rule of law. And if somebody punishes you without a trial entirely, that's not the rule of law, because law has not been applied. And companies know it when they go into a country and they're asked to come in and given all sorts of incentives to come in. And the minute they come in, the country says, we're going to take over your board with locals. And we didn't tell you we're going to do this, we're not going to do it. There's no law about it, but we're going to do it. We know that's not the rule of law. So you know it when it's not there.
Andrew, you've been awfully quiet. Whose rule of law at the international level?
Well, I mean, in answer, as a non-lawyer's, non-legal answer to that question, not yours, his, well, it's obviously not about a specific system of law. It is simply, as I think the Universal Declaration of Human Rights of 1948 said, it is essential so that man is not compelled to take recourse as a last resort to rebellion against oppression and tyranny, that human rights be embedded in rule of law. I mean, so that's really what it is. It's very general philosophical terms, really. In terms of whose law is international law, it is the big powers, I have to say, but bringing along the others as well, because international law, it doesn't come from the Security Council. That is a specific resolution, but international law has to go to the wider membership in the General Assembly. So it's not just, unlike some of the issues I was talking about before, that this is not a case where the big powers can dictate what international law is.
We still have time for one last question, possibly. Sir Kieran is very keen to come back.
On the issue of whose law, I'm quite interested in the issue of victor's justice. Would you like to say something about that? Because it seems ever since Nuremberg that it's the victors who do the justice, and going on through Rwanda and many other conflicts. So does the panel have a view on that?
Well, I think, Sir Kieran, in some circumstances, victor's justice is probably a good thing, right? We want to see some justice and accountability. Certainly, I mean, when you were in your leadership post in New York and Kosovo, of course, there was a push for some accountability of Milosevic in The Hague. So to some extent, that was victor's justice. Some may say there was victor's justice with the killing of and the execution of Saddam Hussein. There's been some victor's justice in other venues as well. So I think it's sort of to some extent we need to see victor's justice, meaningful, deep accountability, including criminal accountability, is a good thing.
I mean, clearly, whenever there's been an international tribunal, whether it's Germany and Japan after the Second World War, or whether it's Rwanda and Bosnia, there would have been no such tribunal, no such justice if the perpetrators had not been defeated. So clearly, there is a form of victor's justice. But certainly, in the case of Rwanda and Bosnia, it's more about victims' justice, because it was definitely the victims were able to confront their prosecutors at the highest level. And say, you did this, you butchered my family. So I think it's victor's justice, but it's also victim's justice.
It was Justice Jackson leading the US team during the Nuremberg trials who pointed out that only if the kind of justice that had been applied to the members of the Nazi Party could also be applied to the victors, and he was talking about the Americans, the Nuremberg principles would have succeeded. I guess that we can still question whether the principles have succeeded, since indeed there is too much, not too little, victor's justice out there. And yet, it is precisely because we can recognize that it is worth defending the rule of law. Please join me in thanking this most distinguished panel, and thank you all for being here.